I would like to get into something that I've covered involving the uh, lawsuit against spying, the espionage operation that was directed against the Ecuador embassy where Julian Assange was living. And he was there from 2012 to 2019 when he was expelled. During that time, he had many visitors that came to see him. And while he was there in the embassy, those people who came to visit him, Americans, they were targeted. We know that this firm that was hired, UC Global, it was contracted to do embassy security, but at the same time, David Morales, the UC Global director, had the UC Global contractors going through phones that were handed over to them. So when you went to the embassy, you had to give your belongings, including your electronics, to the security checkpoint. And you weren't allowed to have it with you when you were meeting Julian Assange. So what we know is that the phones were opened. There were security staff or contractors that were going into the physical structure of the phone. They were taking pictures of the SIM card. They were looking for the IMEI number. And I'll describe why that is so invasive to someone's privacy. I wrote about this in my recent article over at the dissenter.org. Let me go ahead and put this up on the screen here, just for those of you who are interested. Thanks for being here. We've entered the second hour of this broadcast. I don't intend to be going for much longer, but I welcome all of you for being here to watch this. The people who are here tuned in live, thank you for watching. And this is the article. The U.S. says if CIA-backed embassy security opened phones of Assange visitors, it was constitutional. There's another report that I put out. This is over at the dissenter.org. And if you go over there and you become a subscriber, you can get access to all these updates. There's a free subscription. There's a premium subscription. Really encourage you to sign up for this journalism so that you can stay on top of things that are going on with Julian Assange, as well as the attacks on freedom of the press that occur globally and the war on whistleblowers that we see happening on a regular basis. So what happened was there was a motion to dismiss, and on November 16th, they're seeking to dismiss this case that has been brought by 4 individuals, Americans, and the attempt is to challenge the espionage operation that we know was carried out against Julian Assange and to say that the privacy rights of Americans were violated in violation of the Constitution. This was in August 2022. 4 Americans sued Margaret Ratner Kunstler, a civil rights activist and human rights attorney, Deborah Herbeck, a media lawyer who represented Assange at WikiLeaks, journalist John Getz, who worked for Der Spiegel when the German media organization first partnered with WikiLeaks, and then journalist Charles Glass, who wrote articles on Assange for The Intercept. When they went there, they were required to surrender their electronic devices. We know that there was a folder that was marked CIA on David Morales' laptop. So you can no longer say that there wasn't some kind of a connection happening. What's unfolding and gets no attention except from this channel and then maybe a few other places. El País has been covering it in Spain. There is a Spanish criminal case that has been unfolding against Morales and a few other individuals from UC Global that was brought by Assange, alleges privacy violations and goes after them for their role in facilitating the spying operation against the Ecuador embassy. It's everybody who was inside of it. They were primarily targeting Assange, but they bugged it. They planted microphones, put them in the extinguisher, the fire extinguisher. They put the microphones in the women's bathrooms. They were going after attorney-client privilege material. They were going after conversations he had with his doctors and nurses. We know that people were designated priority targets. The reports included meeting dates, copies of passports of Americans. There were contents from conversations with the WikiLeaks founder. And then there's videos of the meeting that we know existed. There was a constant feed and it's believed that they had access. On some occasions, the casing of the cell phone was taken off. It was opened. They were photographing the International Mobile Equipment Identity Number, the IMEI. It's a unique code that identifies a device, and it's one of the most valuable pieces of information for anyone looking to hack a phone. This is part of identifying you as a subscriber when you're using mobile services. When a cell phone connects to a network, this identity number is automatically transmitted. And so this came up in the course of this hearing, and I cover it, but I'm going to go and give a fuller picture of what was happening with this rare court hearing that typically we do not have this. We do not have moments where oral argument is allowed by a U.S. court to come in and challenge CIA spying. When's the last time you saw any news about holding accountable the actions of, or attempting to hold accountable the actions of the CIA globally in a court setting? And that's something that now the U.S. attorney, an assistant U.S. attorney, Jean David Barnea, has been invited to or has been tasked with representing the government and defending the CIA and Mike Pompeo from this lawsuit. And so he came in, Southern District of New York. They were at this courthouse. This is the U.S. Attorney's Office in the Southern District of New York. There's Pompeo. Of course, he labeled WikiLeaks the non-state hostile intelligence service, very aggressively going after WikiLeaks when he was the CIA director. So we presume that anything that was happening with the embassy, it's some kind of involvement. We have reports that there were sketched plans to kidnap or assassinate Julian Assange. So CIA and Pompeo, the targeting of the embassy, they are at this courthouse, and John Kodal is the judge. So John Kodal and this assistant U.S. attorney, Barnea, are there, and they're going back and forth over what was alleged to have happened, what these Americans have alleged happened when they were targeted at the embassy. And before I wind down and wrap this all up, I'll go back to some comments that you have left and engage with you, but I just want you to hear this exchange. And this is from the transcript. This is the transcript of the oral argument. So this was towards the beginning of the hearing. And these aren't very long hearings. They last like 15 or 20 minutes. And then this is done so that they can decide on whether to dismiss the lawsuit. So we don't know that they're going to be able to bring their claims against the CIA. But this judge has been more open than others, and you can hear it. So Barnea laid out the way that he understands the Fourth Amendment. And he says that the cases that the plaintiffs rely on, these Americans, for example, ACLU v. Clapper, that's a case that involved trying to challenge the NSA's surveillance, the way that they were accessing Americans' telephone metadata without a warrant and all of that. This is linked to, let's say, the NSA whistleblower Edward Snowden's revelations, what he brought to the world in 2013. So that's mentioned, and the court says ACLU v. Clapper, and when I say the court, that's what it reads in the transcript. So when I say the court, I'm talking about the judge. ACLU v. Clapper talked about not only the collection of the information, but the maintenance in the government's database. Right, Barnea said. And again, maintenance there, I think, is different from what we are talking about. The allegations in this case, the maintenance was an actively used and regularly accessed database that was, as described in the Second Circuit's opinion, one that the government regularly looked at, and necessarily, by consistently examining that database, was sort of necessarily looking through, among many other records, the plaintiff's own records. Okay, I don't really know what he just said there. That's hella confusing. But Barnea goes on to talk about the Fourth Amendment, and he says that the plaintiffs have not alleged sufficient facts that, if proven, would establish that the CIA controlled or directed the Spanish defendants. Plaintiffs assert that the Spanish defendants were approached by intermediaries, supposedly on behalf of the CIA, to conduct surveillance on Assange and his visitors. They claim that the CIA provided some technical assistance in implementing that surveillance, and they claim that the CIA promised contracts or remuneration in exchange for the provision of that information. None of those allegations, even assuming their truth, established that the CIA controlled or directed the actions of the Spanish defendants. The Second Circuit has already articulated, applied a relevant standard, blah, 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 blah. Okay, so the judge asked, contemporaneous monitoring was done from the United States, wasn't it? And then Barnea had to concede that that is what the Americans are claiming. And the judge said, so U.S. agents were monitoring the feed in the United States, and that's not sufficient involvement by the government? Okay, so the judge can identify the bullshit here in the assistant U.S. attorney's remarks, trying to argue that everything that's in this case, by the way, has to be taken at face value for the purposes of the motion to dismiss everything that are alleged. It's not that those facts have been proven, but they are treated as verifiable fact, and the government has to be able to rebut it. And so saying that there's evidence that the CIA was able to access these audio and video feeds, doesn't that smack of sufficient involvement? That's what the judge was saying there. And the response from Barnea, which is a bit baffling, the question is not involvement by the government, but it's control and direction over the foreign actor by the U.S. government. So the question is, were the people who were doing the actual searches and seizures abroad controlled and directed by the U.S. government in the relevant sense in order to implicate the Fourth Amendment? So, in other words, gibberish, but the judge asks, why isn't there at least an issue of fact as to what the involvement of the government was? So if it's a question of fact, then those are things that could be handled during a trial, or there could be, this is a civil suit. So there could be there would be a trial that would happen over the civil suit. If the Americans were able to prove the evidence of espionage with CIA involvement, then they would win the case. So they're alleging that those facts are there, and they want to go through discovery and find out these details. So the judge asks about that aspect. And he claims that we're saying, if you look at the allegations, this is Barnea, the assistant U.S. attorney, we are saying if you look at the allegations in the complaint of the CIA's involvement here, it does not rise to the level that would satisfy the standard. Okay, so I'm going to scroll down and just go to a little bit more here. So the judge disputes this idea that there isn't any involvement on the part of the U.S. government. And we get into the Fourth Amendment, and they get into the issues around whether the Fourth Amendment has any protection for people who go to the embassy. The position that the U.S. government is taking through this lawsuit is that when you, as an American, if you're an American, if you're not from America and you're watching this broadcast, then just enjoy learning that we aren't really the democratic, free state that everyone in power claims we are. But they're saying that Americans, when they go to embassies or they travel anywhere abroad, basically, you have given up your Fourth Amendment protections for and against warrantless surveillance, to the extent that those even exist, and they're not even enforced. There's no repercussions for anyone in power violating that. We have a total surveillance state. There's a wide apparatus that can target just about anybody that wants to. And this is part of what we've learned when it comes to a lot of the surveillance that still exists, the remnants of the Patriot Act and so on and so forth. But to the extent that we claim that people who are Americans should not be targeted, they got into a conversation about the Fourth Amendment and if it could protect those people who went to the embassy that were Americans. And in having this conversation, the court came on something peculiar, and this is the last thing I'll highlight because I found this to be one of the most remarkable exchanges. It's the part where the court notes that plaintiffs allege that the contents of their electronic devices were seized, and you don't seem to dispute in your paper that a warrant would be necessary. It would be necessary to seize the contents of the electronic devices. And then the assistant U.S. attorney responded, I don't believe that a warrant is ever required outside the United States. The Second Circuit has held that the warrant requirement of the Fourth Amendment only applies within the United States. And the judge asked, what case tells you that that is the way things are supposed to be? And Barnea, the assistant U.S. attorney, replied, the bombing in East Africa. The U.S. embassy bombings in East Africa, among others, have held, I guess there's a case around this, I'm not that familiar, that the warrant requirement specifically of the Fourth Amendment does not apply extraterritorially. There is nonetheless a reasonable requirement that applies from the Fourth Amendment to surveillance by the U.S. government of U.S. persons abroad. The judge says, no. We're talking about the plaintiff's allegation that that they left their electronic devices as well as passports, and that the outsides were copied. And you said no expectation of privacy with respect to that. And there is a section that deals with the fact that the plaintiffs allege that the contents were copied. And the only response that I saw in your papers was not no warrant is required. You assume that a warrant is required for the contents of Americans' electronic devices that are left at this embassy. But you say the plaintiffs have not alleged that no warrant was obtained. So there's some dispute about whether that's what actually was said. And then there's this long, sprawling answer that is given, and I'm not going to sit here and read it. But after the U.S. attorney, the assistant U.S. attorney spoke, the judge said, I frankly don't understand what you just said. And they had to break it down. And as they broke it down, the judge made it clear that he had read in the government's response to this lawsuit that these Americans have not alleged that there is no warrant, that no warrant was obtained to access their phones, their electronics, their belongings, etc. So therefore, they have failed to state a claim for a violation of the Fourth Amendment. This is interesting. So the judge says, you're telling me, no, that's not what you said. I'll go back and read your papers with much more care. I did read them with care initially. But the next question that I have for you is whether a warrant was obtained or not. Can you tell me now? The implication of what you're telling me is, of course, there was no warrant. No warrants are required to seize the contents of a phone from an American citizen abroad. He's asking plainly, did you get a warrant to target these people that the UC Global contractors were collecting all of this from their property? There's feeds, there's audio, video feeds. The CIA has access, or someone in U.S. government intelligence agents are watching this. People are accessing these feeds. And the U.S. government's response is that a constitutional warrant requirement of the Fourth Amendment does not apply outside the United States. Again, restating that they believe that people who go to this embassy have lost their privacy rights, have no reasonable expectation of privacy. Not just because, in this breath, he's not saying it's because Julian Assange is a national security target, which they've also said that as well. But in this, what they're saying is just plainly, no matter who is in that embassy, they do not have privacy rights. It's extraordinary. This is something that I think everyone should consider, because what they're telling you is that if you leave the U.S., you do not have constitutional rights. And that's not how I understand, and that's not how the attorneys represent these Americans understand the Constitution and the way it is supposed to supposedly offer some kind of privacy protections. So they're really blowing a hole in it. So much like they're blowing a hole in the First Amendment, again, with Assange, they're to blow a hole through the Fourth Amendment, it seems like, if they can, or at least in order to defend the CIA, they're pretending like the Fourth Amendment isn't what it is and has been on the books for decades, for over 200 years, right? So here they go. And they're still going back and forth. And this goes on and on. But again, like, the point of all of this is just to say that the judge pins them down and says, do you have a warrant? And they refuse to confirm or deny whether they got a warrant. They won't speak to the facts at all. And now the judge is probably, understandably, vexed by all of this. What they decided to do is allow the lawsuit to be updated. And so the next development in this lawsuit, if you're wondering where this goes next, is that they are going to have the lawyer for the Americans put forward the claim that there was warrantless surveillance against them, and that's what needs to be addressed. And then the government will have to respond to the allegation that the surveillance happened without a warrant, and they'll go back and forth. And then that will become an element of the decision on whether to dismiss the case. But what we're seeing here is that I think this case is stronger than the US government would like it to be. And it's a much harder thing for them to deal with. And I think potentially much harder than what we saw from human rights organizations that were challenging NSA surveillance, trying to say that they were harmed, that there was injury. These are specific individuals. They went to this embassy, they visited. Those embassy security are not police, but the US government keeps acting like they were police officers, so they should be allowed to go through people's electronics, rifle through belongings, and violate your privacy in ways that the police get away with in the United States. But those people, they're not deputized to do any enforcement of the law or policing for the US. They're in the embassy. And the idea that this is normal what happened to the Americans who visited Julian Assange, journalists and attorneys who had their confidential sources compromised or attorney-client privilege information compromised. The idea that this is normal, that you go to an embassy, they take your stuff, they take photographs of your phone, they take it apart, they pick it apart, they might have a tracker planted on it. Who knows what kind of malware you have on it as you walk around? Do you have spyware on your device? Who fucking knows? You're now in trouble and you're walking around after you visited. The idea that it's normal that you do that happens to you because you went in an embassy that has video surveillance. That's what they say. They say that there's video surveillance there and there's a security checkpoint. So you give up your reasonable expectation of privacy. So basically, the normal surveillance that happens at government or diplomatic buildings has become a cover for allowing the CIA to come in and violate the privacy of everything that you own that is your personal property. That's what's happening in this case. That's why it's essential for people to pay attention to it. These arguments that are being put forward show the naked power that the US wants to exercise globally. It's in this hyper-focused instance of going after Assange in the Ecuador embassy, but we really need to consider the ramifications of what the US government is asserting here and the extent to which they believe they could work with diplomatic security of any embassy. I think it's a threat to lawyers, it's a threat to human rights people, it's a threat to press, it's a threat to doctors who might be meeting with political prisoners in these embassies. So if they're on the other side of the equation and are not working in concert with what US foreign policy wants, then those people are going to be targets. They will be priority targets like Julian Assange.